Good evening and welcome back to Live Law Academy. We had discussed our first case with respect to Bulldozer Justice, the topic that we started in our previous class. Now, moving to the second judgment, that is again related to the guidelines and the directions issued by the Supreme Court for the demolition of structures, whatever residential, commercial structure. The guidelines have been laid down by the Supreme Court in this case. If you have not attended our previous class, I would urge and request you to refer to the previous judgment, because that is the class wherein we started with all that is written over this particular screen right now, right? So whatever you see here, bulldozer justice, right to property, separation of power, these are the important facets and aspects with respect to this case, which we did cover very briefly in the previous judgment. You will just get an idea as to how it is related to this case from understanding and referring to the previous case. Now, in today's class, we are going to continue with this particular decision and to understand how the judgment covers various concepts like separation of power, rule of law, which we all have studied or have heard of right from the preparation days of our law school, from CLAT preparation, then studying it in college, wherever, whichever stage you are, you must have referred to these terms. Now, accordingly, we will see that how it has been applied by the Supreme Court in this particular given judgment, right? So I'll take you through the index of the case for you to understand that this judgment is about the guidelines that have been issued by the Honorable Supreme Court for the directions or for the orders that are passed by the executive for demolition to be done. Demolition of structures, right? Whether the executive has the power to do the same, whether it is so allowed under rule of law, whether the separation of power makes a distinction between what is the judiciary supposed to do and how the executive is required to pass these orders, what is the limitation that is so there on their powers. Then we talk about doctrine of public trust as well, right? So public trust is something which is primarily, which you may have heard of for the cases related to environment law. But not just that, here also the judges have acknowledged that this is a concept wherein the state is expected, the state has been given certain duties and they have to work in the favor of the people, right? So the idea of trust, and then accordingly expecting the state to work for the benefit of the public. So that is something the discussion is going to be about. Then rights of the accused under constitution. When we talk about accused and convicts, okay, we are talking about a free citizen, then we are talking about an accused, and then we talk about a convict. In all the cases, our constitution provides you a certain set of rights, and it is our duty, it is the duty of the state bodies to preserve these rights, correct? So whether these accused, merely because they are an accused, they can be deprived of their property, demolition of their property can be done. On top of it, it is not only the accused who is residing or who is occupying the property, they also have family members who are so there. So even their right to shelter gets affected. And what is the idea of collective punishment? Whether the family members, can be collectively punished for such wrongful act done by one person who is accused, who's merely an accused. And that is why the concept of presumption of innocence, that if you are merely an accused, the criminal jurisprudence talks about the concept of presumption of innocence. It protects the right of these accused, and therefore how can the executive, by merely passing an order, destruct or take away their right to the property? And then the last and the most important aspect, that is the directions that have been given by the Honorable Supreme Court in this case, which are to be followed in all the future cases. And these directions are, it starts from the stage of notice, it goes up to how the notice has to be put on the portal, how hearing is to be done, how the order is to be passed, what will be the authority for you to challenge the final order, whether demolition, if allowed, is to be, is to be done in a particular manner. It has to be videographed, where to keep the videography. All of these are guidelines and directions that have been given in the judgment. So very exhaustively, 100 pages of judgment. In the last class, merely 15 pages, but we did discuss it at great length, and it took us around 40 to 45 minutes to understand that case. So here 100 pages, but we are going to read every aspect and try to get the summary of this judgment. So there were a bunch of petitions that were filed before the Honorable Supreme Court, challenging the different orders passed by the state executive for demolition or for the destruction of the structure, and all of them have been answered in this case. Okay, the idea of reading the entire judgment in this class, in these discussions that we do, is primarily to first tell you how to read a judgment. So what happens is, we already, we have this restriction. We feel hesitant in reading the entire judgment because it may take a lot of time. But here we try to summarize. We show you the copy of the judgment, so you get an idea that we are not missing on anything. Secondly, we explain it in a very easy manner, so that in your 40-45 minutes you can understand the idea of entire judgment, relate it with different laws, understand the applicability of it in your exam as well. And then if you're a lawyer, or if you're a student of law who has not yet decided to prepare for judiciary, then in that situation, it at least exposes you to understand reading of judgment. There are different facets, right? Like, for example, there is a poem with which this particular judgment starts, right? So you can read this poem. Once you read it, you can pause my video and take a second to read it. The summary or the idea of using this poem here is for the people to understand, for the authorities to understand the idea of home, the idea of having a shelter, and why have we protected this right to shelter under the Constitution of India. So that is the idea of starting with a poem in the beginning. Then in addition to this, I'll be taking you to this particular paragraph. Okay, very important. If you read this paragraph, even though this is by Lord Denning, which in one of the judgment which was so used by him, we try to read this paragraph and we try to understand the summary of it. This will give you an idea as to what is the importance, or what is the extent of protection granted to your right to property. Okay, so he has said that the poorest man may live in his cottage, bid defiance to all forces of the crown. Okay, it may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his forces dare not cross the threshold of the ruined tenement. So be it, unless he has justification by law. So what is basically this paragraph telling us is that if you have your house, okay, your shelter, where you feel protected, maximum protection that is so available to you, where you feel safe, here, nobody can encroach. Wind, rainfall, storms, all of this may come, but the crown or the representative of the crown cannot enter without the justification by law. This is the important part. This is the due process of law. Unless and until the law allows so, you cannot be deprived of your right to property. So this is the summary with which we begin. This is the summary or the idea with which Justice Gawai has begun, and he has explained very nicely the issues that are so here, and how the different directions that are expected for the state machinery to follow in future as well. Okay, so we start with this paragraph. Then, as I told you, that these are different petitions that were filed, wherein they are challenging that the decision taken by the state machinery has been precipitative, has been very hasty. They do not give enough time, they do not give enough notice, they do not give enough reasoning, and they just merely come and destruct or demolish the property of an individual who is a convict or who is an accused in criminal proceeding. Then the petition also urges and also seeks for the court to take strict action against the officials. The officials who have violated the statutory duty imposed on them, they must also be punished, and strict action may be taken against them. Okay. Now, when you will read this copy of the judgment, you will see that there were multiple inputs given by different senior counsels, different counsels in this case. We will not be getting into the summary of their suggestions, because the important part, or the part that has been, that has been seen to have implementation, or seen to have possible implementation, has been included in the direction. So we will rather cover the directions that are given by the Supreme Court. But here you see as to how the amicus, how the friends of the court help the court in understanding any issue that is before them, right? So these are different suggestions which were collated and which were put before the court. But we move to the actual finding, and we move to the reasoning taken by the court in the deciding of this case. So let's go to that. Firstly, as I told you in the last judgment also, the scope of the judgment, the scope of the present petition is always elaborated by, in this case it is very clearly written, the scope of the petition. In the previous case it did not use the term scope, but they highlighted that we are not discussing these questions, rather the issue at the hand, right? So likewise here also, the scope of all these petition is to understand that what is the right of people who are accused or who are convicts with respect to whether demolition of their property can be done without following the due process of law. So this has been the scope of this particular judgment that is given, and that has been highlighted as well. Now we start one by one of the explanation and the understanding of different topics like rule of law, separation of power, public trust doctrine, etc. Okay, I'll just tell you one thing. I am not taking a lot, we are not studying constitution here, we are trying to understand the judgment. So I will not be devoting a lot of time telling you what is rule of law, but we see the important part of rule of law as discussed in this case. Okay, so rule of law, as propounded, as given, as conceptualized by A.V. Dicey, has been summarized, has been mentioned here. Rule of law, as we understand, as the judgment started with talking about the crown's power being limited with the justification of law. So it is the law which is more supreme, and out of that every authority, whether state authority, whether the crown, will be extracting their powers from. So that is why rule of law suggests that whenever there is breach of law, it must be established in the ordinary legal manner. No man is above the law, the predominance of the legal spirit. All these are different connotations for us to understand that it is the spirit of law that will have supremacy, and everybody, be it an individual, be it a statutory authority, be it any particular official, everybody is equal before the law, right? And therefore there are mechanisms and there are institutions which enforce these legal rules, which are whenever they are breached, and including the government officials in the same threshold. We say that everybody, whether it is the government officials, citizens, everybody is bound by the law, and they're supposed to abide by the law. Okay, we only stick to the important or the highlighted portion in the discussion. So how did this practice come into picture? We go back in time, we see the concept of apartheid that was there in South Africa, we talk about slavery that existed in the US, and then we talk about untouchability that existed in India. All of this suggested that all of these gave an idea to individuals or to people to rule over others or to decide what is wrong and right for them. Therefore, to get away with this, these were all antithesis of rule of law, and rule of law works or is based on human dignity. It says that it is a law which is going to be superior. No person is superior to the other. So when the executive, when the judiciary is deciding something, they cannot be doing it going beyond the power that is given to them by virtue of law. The discussion of rule of law in this context is this, that none of the bodies, okay, none of the bodies can be going against the power granted to them by virtue of law and deciding something against the rule of law. In the modern sense, we can understand rule of law in different concepts, such as the democratic accountability, procedural fairness, substantive grounding. For example, when you are being punished, you must be, it must be clarified, it must be informed, it must be proved that it is being done on a substantive grounding. There exists a law for us to punish you. Secondly, the punishment that is so put on you, the procedure for us to tell the court, for us to convince the parties as well as the court, is or should be based on fairness, should be something which is so laid down by the virtue of law. So these are different aspects wherein we see the modern concept of law. And then referring to this particular part, we understand that here we are seeing that it is not an abstract concept. Rule of law is not something which is a twinkling star, rather it is a terrestrial concept, wherein we are saying it is something that exists in the society, and therefore it is for the protection of people, and accordingly it should be followed by the authorities for the people as well. Okay, then we had this case of NHRC versus state of Arunachal Pradesh, which was about the Chakma community who had migrated in Arunachal Pradesh, and there was a lot of, uh, violation of their rights done by a group of people, wherein the court highlighted and said that it is the duty of the state, it is the obligation of the state to ensure that no group is assaulted by the other group. Everybody have, everybody have to say to be safeguarded, their rights have to be safeguarded by the statutory bodies. And that is how the states have been time and again recalled and have been informed about their obligation and duty, which is, always to be vigilant. Then in the other judgment, we see that how the courts have been told. Now here in this case, the interpretation suggests us that it is the judiciary which has to come forward and which has to be vigilant against the state action. If the state action has violated or is threatening to upset the rights given to individual, in that situation it is the judiciary which must come forward and protect the foundational values of democracy. Okay, so as we discussed, either the private individual or the state, all are regulated by the general principles of law, general rules of law, and therefore there is no discrimination. They have to be treated alike in every situation. Okay, now, the judiciary is the guardian of rule of law and central pillar of democratic state. So, as we are understanding, when we are reading rule of law here, we are basically trying to trace that in different judgment, all these are landmark ones as well, right? So, in all these judgment, we have seen that how rule of law has been established. Secondly, the other aspect of it is that how judiciary is expected to protect rule of law, and that is what has been done in this particular case. So, various highlights of rule of law not being an abstractive principle, being a substantive content, and how it has to be seen in a society. Then we also say that here we have to refer that if there is a process enshrined in constitutional law, criminal law, procedural law, it is based on rule of law. Let's say when we talk about the different procedural requirement, if there is demolition or an order of destruction that is to be passed by the state authority, it must be based, or it must be, coming out or springing out from the procedure that exists in the law, understanding and believing that the law is based on following the principle of rule of law. So to regulate the executive power, we have certain procedural requirement, and if those are not done, then in that situation we will consider and we will construe that this depicts that this is violation of rule of law. So this is the discussion on rule of law. To summarize in 2-3 sentences, it can be said that firstly, neither executive nor judiciary is above law. It is the law that will be regulating every body of the state, right? Secondly, if in a given situation the executive is seen to be passing orders or is seen to be giving directions which are against the written law, against the idea of law, then the judiciary is expected to come forward and to protect the law in such a situation and protect the rights of individuals. Thirdly, neither the individuals nor the state machinery, none of them is above law, and the law must be followed, and the law must be superior to both. Okay, now after this we get into the question of separation of power. This is an important discussion because here we try to identify whether The executive has the power to decide, to adjudicate. The judiciary has been very clearly given certain set of powers wherein they adjudicate and they decide the issues, right? They decide whether something is right or wrong, and it is based on hearing the parties. It is based on the principle of natural justice, where you provide them the window, where you allow them to defend their case. But when the executive merely on the ground, because you are an accused, decides something, will that not be encroaching, or will it not be usurping the power of judiciary? If yes, then how is, then if yes, then it will be violative of separation of power. And separation of power being the part of basic structure, it is going to be violative of different rights of individuals as well. So this is a summary of what we are going to understand from separation of power. If you know separation of power, we do not have a straight jacket formula of separation of power, but we do follow the same, right? And therefore, we have different power. So it has been so mentioned and quoted in this case, where we say that it may not be possible to frame an exhaustive definition of what the executive function means and implies. But ordinarily, the executive power connotes the residue. So it is definitely, we are acknowledging that the executive has the residuary power of whatever is left from the legislature and from the judiciary. The executive may work on it, but there is no absolute rigidity, and rather we have to ensure that neither of the bodies are usurping or taking away the power of the other organ. So our constitution does not contemplate assumption by one organ or the state of function that essentially belongs to another. So we have to very strictly manage the division and accordingly respect the same. That has been the first discussion. Then we also acknowledge that we, our parliament and our judiciary work in a different manner as compared to British parliament. So one example that has been quoted here is that the Indian parliament will not direct that an accused in a pending case shall stand acquitted or the suit shall stand decreed. This is the adjudicatory power which is available to the judiciary. Now there's an example also that is so mentioned, goes back in 1500s, where there was a bishop of there was a cook of a particular bishop who had poisoned the food of the bishop's family, and two members of the bishop family died as well. Now here, what is the punishment that is to be given to the cook was decided by the British parliament by making a law. They decided as to, he was, I believe he was boiled and he was cooked in this man, he died because of boiling. Okay, and this act was done or was passed by the legislature, British parliament. So therefore we have made a distinction. We say that the British parliament may have the power to decide on something, to direct whether the accused should be punished or not, what should be the punishment given. But Indian parliament does not do so. Indian parliament makes law, and it is the judiciary which decides as to what should be the punishment given. So if in a given situation the judiciary feels that this is this demolition or destruction of twin towers is to be done, it will be decided and it will be adjudicated by the judiciary, because the power lies with them. The state machinery, especially the executive, should not be allowed to do so. So this is another discussion that has been done. Then we acknowledge that why separation of power and why it was so introduced, to prevent tyranny, to bring checks and balances, and that has been the idea, and that is accordingly followed also, wherein whether it is an administrative body, whether it is a private functioning body, everybody has to work in a manner where checks and balances will be imposed in them. Then this was about executive and as to how we see the working of executive. Now coming to the other discussion as to how judiciary is to be seen. Has the judiciary regulated, or has the judiciary given guidelines for the working of executive in the past, which they are doing now in this case? So yes, the judges have clarified that there are multiple cases, like as we highlight here, that certain spheres like environment, sustenance on social interest, empowering populace with the right to information, right to know, all these, or the candidates relating to contesting election, all these have been the ambit wherein the judiciary has laid guidelines. These guidelines have been laid to regulate and for, for the assessment of how the executive is supposed to work, and this has been done previously. Likewise, it will be done in this case also, and this is the power that is available to the judiciary. So when we talk about constitutional limitation, we at the same time acknowledge that the judiciary has these rights available to them, by which they have issued directions, they have formulated guidelines, and all of this has been done to further the idea of justice, to further the idea of protecting the fundamental rights of individuals. So this is the next discussion, and then we come to the questions. So if this is separation of power, ma'am, if this is how executive is working, if this is how judiciary is working, the question that comes here is, firstly, whether the officers can adjudicate or not. Okay, so when the adjudicatory function are entrusted to the judiciary, can the officers of the state government take upon themselves the adjudicatory function? As we understood and as we discussed, can this be done by the executive? Secondly, when a person is undergoing trial and there's no conclusion of the trial, can they be inflicted with a punishment of demolition of their property by such executive order? These are the questions that the court has highlighted by summarizing separation of power, that we are going to answer both these questions in the judgment. Okay. Then moving to the third discussion, that is based on public trust. As I told you, we see the government, we see that this entire concept is coming from trust. Okay, trust, how we have, all of us, if simply to understand, all of us have together given our rights to the state, and therefore the state becomes trustee, and our rights are expected to be protected by them. Then in such a situation, can the executive be violating our rights? And if they are doing so, will it not be breach of the doctrine of public trust? Okay, this is the context. So the context is that the state becomes trustee of our rights. How? Because all of us have cumulatively given the power to the state to protect our rights. In such a situation, when the state itself is violating our rights, is it not violating the concept of public trust as well? In addition to rule of law, in addition to separation of power, they are also breaching the doctrine of public trust and accountability that is imposed on them. Okay, so this is the discussion as to how the court have acknowledged in this case that how public trust doctrine is also violated, how the judiciary, the doctrine of full faith and credit is there, and the judiciary and executive both have to take enough protective measures to protect the rights of individuals. Okay, then there are examples given in the judgment. For example, delayed decision. If in a given situation you were expected to, the state machinery was expected to work in a prompt manner, if they have given delayed decision, definitely that is also violation of statutory rights, and therefore they have also failed to fulfill their statutory obligation. Okay, so these are different discussion as to how public trust doctrine have been violated. Now, another important aspect, what is the state really expected to do? So in this particular landmark case of Neelavati Behra, the judiciary has highlighted, very clearly demarcated, that we acknowledge. Now see the evolution in the remedy that we are expecting to give. Okay, they have said that we acknowledge if there is violation of right and it is done on the basis of failure of state machinery, definitely the person has the window open to them, or the aggrieved party has this window of going and seeking remedy by way of a civil suit. We acknowledge that. Okay, but at the same time, we also have to see beyond a remedy, beyond this, an active tool beyond this, by which we can provide the maximum remedy to the person. So therefore, in this particular case itself, they answer that why not allow the person to file a case before, by way of a petition, writ petition, and accordingly give them remedy here. Not to tell them that please go and file a case under under torts law, and go and invoke the civil jurisdiction and then accordingly take remedy from a civil court, but rather court can grant remedy by way of public law. Okay, so these public law constitutional rights that are available, and therefore they can also seek the remedy by invoking the writ jurisdiction and saying that this is violative of my Article 21. So these are different facets by which the judiciary has expanded the horizon of providing protection to the right of the person. But at the same time, we also understand that it is the judiciary. Now, when the judiciary is doing so, when the judiciary is saying that we are moving beyond and we are telling you not only go by the written law that is there, which has been made by the legislature, rather we are making a new tool for you. So isn't it where the judiciary is actually legislating? Isn't it where the judiciary is usurping the power of the legislature? This is how we have understood, and this is how we are seeing, or the lens by which we are seeing this particular judgment. Okay, but again, this has been done with an intention to protect the right of people, and this has been done with an intention to promote the doctrine of public trust. So to quote here, it says they must be replaced by new and up-to-date machinery by declaration, injunction, action for negligence. This is not the task of parliament, but rather the court must do this. So we are highlighting and very clearly mentioning that we acknowledge that it is the duty, or it is the power of the court to provide such remedy to these bodies. Okay, so that is how public trust doctrine has been summarized in the given case. Then the next discussion is about the right of the accused under constitution. As I told you, there's a very interesting statement made here, that we acknowledge that even a father who's very pious, who's very pure, he may have a son which is very stubborn and which is going to create a lot of nuisance, and he will be a miscreant. So in that situation, do you punish the pure father, the pious father, for the wrongful act of the son? No. So that is how we see that firstly, the right of the accused. When you are merely an accused, the concept of innocence, the concept of your rights will be seen. At the same time, we also attach the right of this accused with the right of his family members, whether the family members can be collectively punished for the wrongful act done by the accused. Okay, so we have mentioned here that we acknowledge and we protect the right of the incarcerated individuals as well. So people who are convicts also, we are protecting their rights. Okay, we do this discussion in our torts law lecture also, wherein we understand that what are who has the right to sue, who has the right to be sued, and then what is the protection available. So therefore, these people have a right to live with dignity, and the punishment has to be in accordance with law. If you are giving them any punishment which is against the idea of presumption of innocence, which is against the written text of law, then that is against the idea of law, and it will not be considered to be correct. So there are examples that we can see here when we talk about the right of convict and accused. For example, the case of Sunil Batra, for example, the case of Charles Shobraj, the recent judgment, Sukanya Shanta judgment given in the last year, and there are follow-ups that are being done in this year, wherein all these situations we talk about prisoners and their rights. Not to put iron fetters, not to put handcuffs, not to give solitary confinement, not to do cellular segregation, not to make discrimination on the basis of caste, not to send them away at a very distant place where the family members cannot reach out to them. All these have been, discussions by which various judgments have flooded and recognized the right of these accused persons. So when we have all these rights, when we acknowledge that these rights are not static, rather we continuously evolve and expand their rights, then in such a situation, how is the state machinery here exploiting the right of the accused and passing orders of destruction and demolition of their house? Okay, so that is the context, or that is the summary of understanding the rights of the accused with respect to protection of their property. Then, as I told you, that the principle of innocence also has to be seen. When you're only and only talking about an accused, you can't go against the criminal jurisprudence. You can't go against the idea that is so there present in our legal system, which is the foundational idea. And therefore, if the state machinery is doing so, it is violative of all these principles that have been recognized by the Good. Okay, so that is another discussion. Then right to shelter, that is right to live in the house, right to co-own the house, all these are different set of rights that have been mentioned with respect to the right of an accused. And therefore this, when we talk about land acquisition, which we did in the last class, all these have to be seen in context of whether it is so done or whether it is so allowed by due process of law or not. And that is how the judiciary in this, or the judges or the bench in this particular case, has realized that the local or the municipal bodies were breaching the law, were going against the idea of law when they were passing such order. Okay, so they are violating the right to shelter as well. Then we have doctrine of proportionality, which suggests that you have to bring a balance between the right and the restrictions that are so imposed. So a person, even though an accused, has right to his property, right to shelter is available to them, and it must be restricted by the law, by the text of law. And that is how you bring proportionality in the right as well as the restriction. So that is also something that is missing in the given case when you see these collective orders. Okay, then we talk about collective punishment, right to shelter of the accused. If you are an accused, you have right to shelter. But let's say we are passing an order by which we are destroying, or we are demolishing your property. Your family also live there, so your children also live there, your parents also live there. So do we follow or do we permit the concept of collective punishment? No, we do not follow this, right? Our criminal jurisprudence does not follow, and therefore it becomes really it is wrong on the face of it when you follow and when you allow an order by which all these people and their right to shelter is getting affected merely because they are related to a person. Okay, so this is how the collective punishment part is also criticized in the given case. And coming to the direction part, so whatever we have discussed so far is the discussion on different aspects by which the directions have been laid down. Now we have decided, now we have given certain set of guidelines and direction, keeping in mind as to what all rights were being violated. Okay, so these are directions exercising the power under article 142. I had asked this question in the last class also, as to where is the power present for the judiciary to give or to pass such directions. Okay, so in all these cases the judiciary has mentioned that you have to provide the person with notice. And what all is there, let's try to get a summary of it. Okay, so at the outset, firstly begin with notice. As we discussed, that you must give prior notice to the person. Okay, show cause notice to them with the acknowledgement due. Provide the notice to the person in person. Secondly, you put a copy of it in the local gazette. Also there is e-portal that they have mentioned that must be established of every state body, and accordingly put the notice in the e-portal as well. Okay, the notice has to be said, it has to be in writing, it has to be said or delivered to the owner or occupier by the registered post, acknowledgement due. It must be, no demolition should be carried without providing a show cause notice, and then waiting for 15 days as well. Okay, so this is the first part of notice. Not just giving it to the person, but also affixing it to a conspicuous place, as well as putting that particular notice in the portal. So the DM has to be informed about it. Okay, the collector or DM will be emailed the copy of the notice so that they also get an idea. The DM has been given certain duties that he has to circulate it to a required number of people who are the authorities that are so mentioned here. Okay, and then you have to also give certain set of details in the notice. So what all is required in the notice is also mentioned here. The nature of the unauthorized construction, you will have to mention the nature. Okay, how commercial, residential, what is the type of the unlawful unauthorized construction, what are the different grounds on which the violation is happening, what laws provides these protection, the documents for the person to understand and also the list of documents that the person has to furnish to you with the objection if they are raising any, as to as to how the notice or how the destruction is or the demolition should not be done. Then also mention the date of the personal hearing. Okay, so as we are understanding, when you're giving notice, the idea is to provide a window for them to come and contest the same. So you mention about the date as well as the personal hearing is also to be fixed, and then you tell the authority also before whom the person is expected to reach out. Okay, then you also have to prepare a digital portal within 3 months from the judgment, and every show cause notice and everything or the videos also have to be put up in this particular digital portal. And then a personal hearing is to be done. Audio altrum partem principle of natural justice, time and again have been quoted in the judgment, by which we are saying that you have to provide the window of personal hearing to the person, and then also must record it. Because we are seeing the violation being done by the state authorities, by the executive, we also want to bring this set of transparency, that when you're calling the person, record the minute of meeting, and accordingly bring transparency so that it cannot, if later contested, you will have certain proof. Then let's say all of this, the parties have been heard, the notice was issued, and now you give a final order. This final order has to be a speaking order with respect to what were the contentions raised by the noticee, how you have disagreed on those contention, what is the reasoning for your disagreement. Always pass speaking orders telling that why you are not agreeing with the contention raised, and if there is an opportunity, if it is possible that the unauthorized construction is compoundable, immediately, or the part of the unauthorized construction is only compoundable, or is not entirely unlawful, then you take penalty or compounding fees and accordingly settle the rights of the people there. Okay, then yes, if only part is there, you accordingly assess the same. You have to very clearly give a reasoning in your final order as to why you are taking a big step. From the beginning of the judgment, we have been discussing and talking about how the rights of a person is important, and how right to shelter has been authorized by the constitution, is authorized by or is promoted by different judgment. Therefore, you have to very clearly mention that why this extreme step of demolition has been taken by you, despite of all these other remedies that are so available to the party. Okay, so this is also something we can do. Then after the final order is given, now again provide another opportunity. So next window will be for you to challenge it before the appellate authority. So if there is judicial scrutiny, that can be done, because so far you are seeing involvement of the state executive only. Now you introduce the window for this party to go and to reach out to the judiciary, right? So therefore, the appellate and the judicial scrutiny of the final order is to be done. Again, provide them time. Do not immediately do implementation of the final order. Rather, let the judiciary do the scrutiny of the final order, and accordingly decide whether the same order is correct or not. If no stay is done, the inspection report is also presented, then all of this is fine, and then you can proceed with the demolition. Now, is there any direction at the demolition stage? Yes. See the level of mindfulness which you can see, or which is present in this given judgment. Now, the proceeding of demolition also has to be videographed. Keep the copy of the videograph, but videograph it. Also, when you are preparing the report, mention that who were the police official, the civil people who were mentioned there, who were present there when the demolition was being done, and provide all these details on the digital portal. This is about the directions that have been given for the different state machinery for them to follow in future. Now, what happens when a destruction is done violating all these guidelines that are so mentioned? Now comes the stringent or the punitive part, that the officials must be aware that there is going to be prosecution as well as contempt proceeding will be initiated against them. So this is now, for better checks and balances, we are saying that the officials will be personally liable as well. And not just this, they will be asked to pay for the cost of the damages that have happened, as well as they'll be asked also to do restitution of the demolished property. If you have taken a precipitative decision, if you have been hasty in your deciding and you have not followed all these guidelines, then you will have to, from your own pocket, provide damages to the party, as well as restore and do the entire construction again. So very stringent when you see this part of the judgment, right? Therefore, after all of this, all these copies have to be delivered, have to be, published and given to all the state authorities, is what is mentioned here. And we end up by understanding that this was a judgment delivered by a division bench, wherein Justice B.R. Gawai and Justice Vishwanathan have delivered a very mindful judgment, collating and telling different directions for the protection of an individual, or especially when you talk about the accused or convicts, for their right to property. Okay, so we are understanding and we are concluding our judgment, today's discussion in this case with respect to demolition of structure. What are the different directions that have to be followed by the state authority, whether they can be encroaching, or they can be getting into the power of the other state machinery, that is so not allowed. How this different bodies, how checks and balances have to be regulated and have to be exercised within the rule of law or the due process of law that so exists. Okay, so I hope this has been easy for you to understand. The judgment has helped you understand the concepts that you are already aware of, which you have heard of, and I hope you will be able to write an answer on all the topics that we have discussed. So you have covered 100 pages, 96 pages with me in today's class, and more or less you saw that we actually referred to almost every single page and concluded the judgment. Okay, so this is, again, I'm taking you back to the summary of where all is this particular judgment going to be important. Do take a screenshot of this page for you to understand what all are the discussion, where all you can expect this question or this topic to be related to. And I hope that this will benefit you, and feel free to write your doubts in the comment section, write your feedback in the comment section, and also if you want us to cover any particular judgment in the coming days. All right, thank you all of you. I'll see you again in the next class, and I hope you have a good day ahead. Thank you.